Right, I might get us started off. Thank you once again for joining us. We are going to be starting with karakia, and I'll be using the whakatauki that was written especially for our organisation. And I will share that on the screen so you can read along as I read it with the translation. Ka hoka a tā hono I uta, ka hoka a tā hono I tai, ka riria a ko whitiwhiti, ka tau ki ko winiwini, ka tau ki ko wanawana, tūturu o whiti whakamaua kia tina, tina, hui e, tai ki e. And I'll just quickly read the translation. As Tahono soars across the seas, as Tahono soars inland, and in leaving those places of significance in the crossing, alights on ko winiwini, on ko wanawana, let there be an affirming of that. Now, let me introduce myself. I'm going to be the moderator for this webinar today. I'll start with my pipiha, which is our Te Reo Māori introduction. Tēnā koutou katoa, he uri tēnei no inia, ko Kamaushami Mraua, ko Aniso Rahman o Kukau Mātua, ko Kirikiri Roa Toku Whatumanoa, ko Waikato Te Awa e mahia nei a ku maharahara, kei Kirikiri Roa ahau e noho ana inai nei, ko Anjum Rahman toko ingoa, no reira, tēnā koutou katoa. So I'm Anjum, based in Kirikiriroa, Hamilton, in the land of Aotearoa, New Zealand. I migrated here as a child of 5 years old, and that meant that I grew up here in the 1970s and 80s. But moving on to more modern times, I've been involved in the Christchurch Call Advisory Network since the beginning in 2019, and that network is a civil society group that is part of the Christchurch Call and is focused on terrorist and violent extremist content online. Just very quickly about our organisation, Tahono, also started in 2019. You'll see that there's a bit of a theme there because that was when the Christchurch mosque attacks happened, and resulted in the death of 51 people and 49 injured. So we as an organisation work to improve belonging and inclusion, and we do this through community development, training, public speaking, submissions to central government, social media, and collaborative partnerships. We've just popped our website into the chat, so please feel free to find out more about us. So one of our community networks that we support is the Coalition for Better. This is basically a coalition of people that are concerned about online harm, not just terrorist and violent extremist content, but a whole variety of harms, ranging from child sexual abuse to scams to stalking to and harassment, doxxing, disinformation, all sorts of things. One of our key partners that I want to recognise is Amnesty International Aotearoa New Zealand, and they developed the No Harmware campaign that will be running over the next year. And we've worked, partnered with them on this, but they have been the lead partner on that campaign. And the reason that we've developed that campaign is also coincidentally the reason why we're holding this webinar is because at the moment we don't have any regulation around online safety in our country, and most of our regulation that does deal with content is old. So for example, the Films, Videos and Publications Classification Act is from 1993, and the Broadcasting Standards Act, which is equally old. So we don't have things that are regulation or legislation that is holding platforms accountable for the design and the systemic issues, for example, how things go viral, how things appear in our feeds, or for their lack of transparency. Recently, though, there have been two pieces of legislation drawn out of the ballot, one of which is the Deepfake Digital Harm and Exploitation Bill, which is really about deepfake porn and those kinds of exploitation, and the Social Media Age Restricted Users Bill, which is about banning social media for under 16, similar to the laws that have been passed in Australia. So to help us talk through this regulation piece, I thought it would be a great idea to get some of my colleagues from the Christchurch Court Advisory Network, who are based in various places around the world, to share with us their experiences of regulation, online harm, and those kinds of things. So we'll be popping their bios in the chat, but just very quickly who we have here, and I'm just reading them in the order that we put them in on the registration. David Greene, who works for the Electronic Frontier Foundation, and there he's a senior staff attorney and civil liberties director, and he works on First Amendment and free expression issues. We have Dr. Katy Vaughan, who is a senior lecturer at Swansea University School of Law, and she's a member of the Cyber Threats Research Centre, the Voxpol Network, and its leadership team, as well as being a co-chair for the Christchurch Court Advisory Network, an outgoing co-chair as it is. Kyle Taylor is an author and leading expert in digital democracy reform, social media, and AI regulation. He's founder of the Resistance Hub, aimed at supporting civil society in exile, and was also a part of founding Fair Vote UK in 2017, and has done a lot more wonderful things. And Seraphin Muderhwa is a digital rights advocate, author, and social innovator, and is the executive director and co-founder of DigiHub Africa. So I want to thank you all so much for agreeing to do this at all the various difficult hours of the day that this is for you. I think perhaps David has it easiest out of all of us here. Before we get into hearing from our speakers, I just wanted to quickly go through the tikanga for the event. So the chat is open, and we will be monitoring that. And the Q&A function is also open. So if you have questions, please throw them into the Q&A. We would ask that any comments that you make, that you are upholding the mana of everyone present and not present, and using respectful language. We absolutely are happy with disagreements and various different points of view and debates, as long as we are behaving with respect. And so when we feel that someone has gone over the line on that, we will probably be removing some posts. Right, let us get into it. So the format is I'm going to ask each of the speakers the same question, and for each question I'll try and do a different order just to vary things up. So the first question that we wanted to address is, when we're talking about online safety, what harms is it that we're trying to address? Because this isn't a simple area, it's actually quite complex. So I'm going to start with Kyle, if that's okay.
Yeah, absolutely. Thanks so much for having me and for arranging this. I think it's the perfect time and context in which to discuss it, and the benefit is that there's so much that's been done globally. It is possible to now start to pick and choose a bit what worked where. And I think when you're looking at my experience primarily with the Online Safety Act in the UK, which I worked on for nearly 6 years, the longest bill ever to move through UK Parliament, and then with the Digital Services Act and other places, is I think a clear distinction between protections you're trying to make for children versus adults. And there's always a demand in the legislative process to differentiate between those two. And then I think from the perspective of the work that I do, egregious harm at scale. So that can be violence and incitement to violence and harassment, or it can be something else like a disinformation campaign that drives people, for example, in the UK, to burn down 5G towers because they're told it spreads COVID. So I think for us, and where we were trying to focus, and where we think legislation should start, is trying to tackle the biggest threats that affect the most people, both from a perspective of age and then a perspective of violence and extremism. Of course, you can get deeply into nitty gritty around other aspects of individual harms, which are important. But I think starting with that which affects the most is what you're aiming at to begin with.
Thank
If that makes
you.
sense.
Yeah, it does. That's great. Thanks you so much. I'll move to you, Katy.
Thank you, Anjum, and thank you for having me for this important and timely webinar. So I'd probably agree with Kyle there, perhaps sharing an experience with the UK's attempts to legislate, and I probably in other questions would go into nitty gritty because I'm also a lawyer, so I can be boring like that. I agree in terms of dealing with so-called bigger threats. So, one issue has been trying to address every single online harm that might be possible. And I think what Kyle has kind of identified is, might not be the right word, but almost like a scale. But I suppose a point I wanted to make here, and goes back to your introduction, Anjum, in terms of the design. So you're thinking about, what harms are you actually talking about? But when we talk a lot about responding to online harms, often there's this discussion about, we're drawn to a discussion about taking up content, pulling it down, not allowing it on the service, on the platform. And we should be thinking about this range of measures or tools that can be taken in relation to visibility of content. So, down ranking, restricting users' ability to share content, thinking about the virality of it, redirecting people who search for it, demonetizing it. And when we think about responding to online harm, that can be important in terms of thinking about, targeting the design perhaps of a platform, rather than thinking about conferring these broad powers, just talking about, removing specific types of content.
Thanks, Katy. I'll pass over to Muderhwa, but I did just want to make a comment, and I might come back to you, Kyle, as well, for thoughts in terms of, it might be that a harm doesn't affect a wide number of people. It affects a small number of people, but really badly. So, for example, when I think about Christchurch mosque attacks, we are a relatively small community, about 1.5% of the population, but the level of hate, around that time and the impact it had was quite high. So yeah, anyway, just some thoughts there. I'll move
No, I
on
just to clarify, I wasn't, I meant oftentimes the conversation becomes about an individual person who's harmed versus a group. So I was very specifically trying to distinguish between an individual person who's experiencing harassment and as something that can affect an entire group or population. So I agree with you.
Thank you. Thank you for that clarification. Right, Muderhwa, I'll pass on to you in terms of your answer.
Yeah, thank you, Anjum. I thank you for inviting me on this. So I'll take on another aspect. I totally agree with Kyle and Katie. So my point, I'm starting with one example, like what happened, like let's say in South Africa. So there's a study that show like 18% of the youth, they've tried to suicide, attempt to suicide due to online harassment. So it is said that it's been done. So for me, the question is, at what time, for example, we say it's an online harassment? So at what time we say it's an harassment against a group or against, I don't know, individual? Because there is, for me, there's quite a bit of ambiguity when it's come to that one as well. Also, there's also a hard when you say the legislator. Okay, we know in I'm taking in the context of most of many countries in, let's say, in Africa, so we have seen this legislation coming in, a lot of legislation when it's come to regulating what is happening online, but we've also seen this being used as a tool, as a tool to go to try to silence some voices. So when you say we call it online, so I'm looking at it as like, okay, it's fine. So how do we, at what point we can say like this is online harassment, or yeah, there's a lot of, for me, ask a lot of questions. I think when you talk about online, there's a lot of assessment, a lot of things that to be done to make sure, especially for some of countries, it's not used for other purpose. So in the same line, I agree with Katie, I agree with Kyle, but I also think when it's come to regulating, we have to make sure like civil societies as well are very well informed, and you have to make sure like whoever is the legislature as well, this digital in most of some of our countries, it's quite new. They don't even get the concept sometimes. So for some, it's just like, okay, I'll bring it. How will you use it? How are we using it for which and this? So yeah, that's how I look at it. It's a bit different, but yeah, that's how I see it sometimes. Yeah.
Thank you. And David, over to you.
Yeah, so I should disclose that I think I'm generally anti or skeptical about regulation of speech. I think that's my role on on this panel, and so I'll just put that out there right away. I'm not a broadly anti-regulatory person in general, but I am broadly usually against, or at least very skeptical of speech regulations. But I do want to lift up what everyone else said, and that the term online harms gets used to describe a ton of different things, most of which require seriously different strategies for addressing them. So, for example, the strategy one might use to address child predation is going to be much different than the strategy one might use to address a hateful viral post. Just for example. And so it actually becomes really important when we talk about harms to actually identify what specific harms we're trying to address, so that we make sure that we are adopting strategies that are specifically targeted to those harms. The other thing that I want to mention that hasn't been brought up is that when we have the discussion about online harms, we too frequently do not talk about privacy harms. And I want to bring that because I think they're highly significant. And to me, it also is an area where there's a tremendous opportunity for regulation, and especially because many of the things we're concerned about with speech harms can be addressed, at least in part, by regulating privacy, by ensuring or strengthening users' privacy rights with respect to the online services they use.
Thank you. I think that's a really important point. And the Online Safety Coalition, which is also interested in this area and working domestically in Aotearoa New Zealand, just ran a webinar last month around period apps and menstruation and people trying to conceive, and the amount of data that they collect that is intimate data that they immediately sell on, and people, you know, not being aware of the impact of that. So I'm really happy that you raised that as an issue. So let's move on to the next question, which is about definitions. So for any legislation, regulation to work, the definitions have to be really clear. And I think there have been examples where the definitions create more difficulties than solving the problem. So I'm going to go to you, Katy, first on this to see if there's any examples that you wanted to share with us.
Yes, I do. And it's from the UK's Online Safety Act. And it's probably, I don't know, to out myself from here is a what not to do from my perspective. So, you know, you're quite right. If you talk about these online harms, we need to know exactly what we're talking about and be clear about how that manifests online. So why we're trying to address online content, whether that be, you know, CSAM, terrorist content, hate speech, and not just in the UK, but existing attempts to define what is meant by that content have been really problematic. In the UK's Online Safety Act, for example, which is aimed at, you know, regulating a broad range of online harms and confers quite broad powers to remove online content. So how it defines that content tends to be quite broad and vague. So it gives this discretion, wide discretion to the regulator or human moderators in private tech companies or algorithms. And then that can make the regulation really difficult to operationalize and become quite counterproductive. So in the UK, the Act labels certain content as illegal content, but it's doing this with reference to existing criminal offences in the UK. So on the face of it, that may make sense as a starting point. It may seem reasonable, and we've seen lots of sound bites about these types of laws and regulation, making it, you know, they're going to make illegal what is illegal offline, illegal online, but criminal offences were not designed to be used in this context. They are directed at conduct. So I know we're talking about online harms more generally, but my own area is, you know, counter-terrorism and thinking about what terrorist content is. So the Online Safety Act takes existing terrorism offences, some of which you have similar offences in New Zealand, and says that this describes illegal content that needs to be taken down. But it's kind of fraught with difficulty. So in the UK, it is an offence. It's a criminal offence to view or download or have in your possession information likely to be useful to a terrorist. The offence doesn't give you examples of what that information might be. What's important is additional context. So with this offence, the courts have had to consider information like a list of fitness exercises, information on avoiding detection, concealing information from others. So what's important in, you know, leading to a criminal conviction is additional context. But that is one of the principal challenges in identifying terrorist content, is the context in which that appears. And we've had numerous examples of tech companies, you know, existing policies missing that context. So my own area is counter-terrorism law, but the UK's Online Safety Act, it takes that approach across other criminal offences as well to define illegal content. So the same issue applies, like including our harassment and stalking offences, hate offences, and extreme pornography. So I suppose, yeah, that's my kind of message. We need to be clear what we're talking about, but ways that that's been done so far are highly problematic and could be counterproductive.
Thanks, Katie. And I guess like one of the harms, and this probably I'm going to go to you next, David, but one of the harms that we do see is where content is taken down when it shouldn't be taken down. Things like shadow banning, or yeah, and that the platforms are doing this even without any pressure or regulatory pressure to do so. Yeah, David, love to hear from you on this.
Yeah, just in terms of practical examples of laws that really struggle to define what exactly is harmful. In the US, most of this is happening at the state level right now, which means we just have a wide variety of laws. There are 30-some laws that are either in effect or that have been passed, waiting to go into effect, most of which are held up in legal challenges at the moment. And those almost all are trying to, as Kyle said, aim at specifically harms to minors. The problem here is that most of these laws are adopting a very ill-defined concept of harmful content to minors, which is not a legal concept under U.S. law. There is a legal concept of material that's harmful to minors under U.S. law that specifically addresses only certain explicit sexual materials that are legal for adults, but that can be, which minors can be denied access to. But it doesn't extend beyond explicit sexual content. And yet these laws are adapting most of these laws are adapting a very flexible concept of material that's harmful to minors, that's intended to extend beyond sexual content, really to give the state very broad discretion to determine, and local prosecutors to determine what specific material is harmful to minors. And I should say most of these laws are not enforceable by prosecutors, but by private actions. Then you even have individuals within a community who are using their own personal view of what might be harmful or inappropriate for minors. So just another example of how difficult the definitions can be here, and how the concept of harm, especially when we're talking about harm to minors particularly, is really going to vary quite greatly among individuals, communities, populations more broadly.
Awesome. Thank you. I'll go to you next, Kyle.
Yeah, I mean, I think what the experience with legislators in particular is that definitions are fun because they're clear and straightforward. And actually, it can be the whole process of actually developing legislation can get drowned in this definition side, as opposed to looking at the bigger picture, the upstream, right? So with tech companies, it's engagement by design. That's how they make money, right? And so if you're upfront trying to define actually the objective of this is to build platforms with safety by design as the core upstream vision of where you're heading, then a lot of other things fall into place downstream, and it's easier to develop legislation that's much more privacy preserving, for example, as well as acknowledge that, with children in particular, by saying, oh, well, they're just banned, you're actually alleviating the company of any responsibility to build a safe product. You're accepting their product is dangerous, which I think is an interesting thing from a defining point of view. In terms of the roadblocks, I think it's not just the terms of the content type, which others have spoken to very eloquently, but it's also the bigger terms around what you're trying to achieve from the bill. So I always look at the transparency and redress as the two core components. I can't put a percentage on it, but 80% of the problems the companies could potentially fix if they knew others would see the problems as a result of transparency requirements, and that they could be punished through redress as a result of them. And then that middle bit is around risk and mitigation. So, okay, you're going to be transparent about how your product works and what's happening. And if there are shortcomings, there will be redress and you will be fined, whatever. And then the middle bit, how does it work? Risk and mitigation. And I'm glad David brought up the question around freedom of expression and freedom of speech, because actually this is another pitfall of people getting trapped in that as a binary conversation, as opposed to a more holistic approach where actually 99.999% of content should not be taken down. But when governments then go between this binary of it's legal or it's illegal, then you end up with it's up or it's down, as opposed to most of what's happening in the social media space, which is very gray. And actually, to Katy's point, you're talking about, great, leave it up, but the platform can't make money from it because it's hate speech, right? Leave it up, but people can't engage with it or share it further because it's inciting, it potentially is going to incite violence. But actually, the leaving it up piece, if it can't be engaged with, monetized, and spread, is not nearly as risky. But that middle bit is where you figure that out. What are the risks and how are you going to mitigate against those risks? And just to give you an example of where we ended up, as a result of the conversation in the UK becoming this binary, we've ended up with transparency requirements that are only have to be met when the regulator requests them, and they don't have to be made public. So what's the stick for companies to be transparent? And then on the redress, the level is so high that if we were to see a fine, I'd be shocked, really, that it would actually be used for redress. And so we've ended up with something that didn't stop the riots last summer and acknowledged it wouldn't have done anything in the UK to curb the misleading information that led to people trying to burn people alive. And a middle bit that's going to take 3 more years to sort out. What do we actually mean by risk and mitigation? And that's not how tech works, but tech understands that's not how tech works. And so anything that slows it down is the goal.
Thank you. I know we do have one question that's come through the Q&A, and I will be posing that to panelists a little bit later on. So, Muderhwa, what would you like to say on that?
Yeah, so on my side, I would say when it's come to Katy and the rest of the team have said most of the points. So when it's come to I know colleagues mentioned regulating the tech companies. You know, this has been one of the major challenge in most of our countries. So you know, the government, when you look at like SA and South Africa, you look at so many African countries, there's progress, you know. When this digital were kind of new, people were trying to figure it out, you know. They didn't see even actually weigh the real risk of this one. It was like just another tool coming in. No one really paid attention on it too much. But as it's evolving and people are seeing what is going on, and we are having online events having real life consequence, people are like, okay, so this one we need to regulate it. And we've seen, like we say, like South Africa, there's this Poppy Act. There are so many regulation regarding this, trying to regulate online presence. So. But the problem is when it's come to the tech companies. So you may see most of these, it's like more of intention. Like, you know, we sometimes feel like many of our government are a bit powerless, you know, kind of. So, but it's coming. We see it's coming slowly. We see some government trying to do a bit more effort to regulate. But you know, when it's come also, there's also a big problem when it's come to language. You know, I know in so many places they've said language is also a problem when it's come to regulating online, you know, online presence. So something may pass in English sometime, you know, they catch it in English, but when you speak to a different language, it go through. So yeah.
Thank you so much. All right, I'll move us along to the next question, which I think I'll go to you, Muderhwa, because you kind of started talking about it already. And that question is, what are the barriers to getting legislation passed in your region? So I just noticed your video is off. Are you still with us?
It looks like he is still on.
Yeah.
I think he gestured as if he had to step away for a moment, so maybe we should come back
Yeah,
to
so let's oh, you're back with us. Muderhwa. So I just was saying if you could answer the next question, which is what are the barriers to getting legislation passed in your region?
So for me, the first thing it will be for me is understanding. Like I was mentioning, the digital it's kind of the new world. Even the legislators themselves, actually, they're trying to understand what is it, you know. How does it impact, like, what is the risk? So there's a lot of first understanding. So when I say understanding, we pull in what we may also call literacy, you know, that we are taking on the side of this legislator. So when you move also on the side of the people as well, there's still a big gap to understand what is going on. And that's why also I would say it's also very risky because we have a big bunch of population just who don't understand what is going on. They're trying to understand what the digital world, what are these concepts. When you say, for example, something, you may say like one of our campaign as DigiHub was like, your online world can have real life consequences. I mean, people don't get it. Like I can throw something online and tomorrow the village is on fire. So the whole concept is quite new. People are trying to understand and to see how it works. At the same time, there's a pressure. It's happening everywhere. Everyone is trying to regulate. Everyone talking about digital. So for me, this is among the barriers. So the understanding, and also one of the problems as well. You see, in some countries, they pass the laws, and I know in one of the meetings where with some organization, civil society from one country were like, you know, we want to see the government talking about these privacy laws. And they were like, guys, you don't know there's a law that is coming next week. They're like, okay, so who did you consult? So stuff like that. So there's a lot going on. Things are happening. You don't know sometimes what is happening. Sometimes our government just push things, not especially in South Africa, but many countries, they're pushing things. Civil societies, we come to realize like, okay, so it's in. So who was involved in this process? And then you start pushing back. It's back and forth. So those are just few elements when it's come to, for legislative pushing laws, we're regulating the digital space.
Great, thank you. Let me go to you, David. US is fun, isn't it?
Yeah. I mean, I think in the U.S. the obstacle has just been political stalemate. And again, I'm not a fan of speech regulation, so in some ways that's been to my advantage. And I think the edge of freedom of expression, but it's also been an obstacle to comprehensive data privacy legislation as well. And I think the political dynamic in the US is that depending on the certain subject matter, one side of the political aisle will be for rules regulating it, and the other side will be against them. And then that just changes as you talk about the different subject matter, which as a freedom of expression advocate is why we don't give government the power to pick and choose the type of speech it likes and dislikes. And I think at this moment in time in the US, we're really sensitive to handing government more power because we're seeing great abuses of it on our federal level. So I do think that when harms start focusing on reflecting specific political preferences for speech and harms corresponding with political ideology, then you are going to see stalemates unless you're at least in multi-party systems where one political viewpoint doesn't have the ability to unilaterally pass laws. So I think that's a decent result. I do think an obstacle broadly to passing really good legislation is trying to address all harms in a single piece of in a single piece of legislation, really, instead of trying to target specific things. Again, I mentioned we always these laws tend to lump predation as a concern, and with content harms, they're very different things. Law enforcement takes very different approaches to how they address them, and when you do that, you start getting people. It's hard to get coalitions around and hard to pass sensible regulation. I think where we've seen bad laws come out, or laws that aren't as good as they could be, and I think goes back to Kyle's point about trying to differentiate between laws protecting young people from laws protecting adults. Lots of times concerns for young people is used as a rallying point for people who otherwise don't agree on things. And then we end up having a serious deprivation of rights of young people, or at least lack of acknowledgement that young people have significant rights. And also we end up not protecting adults. And again, we see this with data privacy regulation as well.
Thanks, David. One thing that did come to me in terms of what you're saying, about having different laws for different types of harms is what I really feel like in terms of our legislative space is we have all these different agencies dealing with different aspects. So you could go to the Media Council for newspapers, you go to the Broadcasting Standards Authority for TV and radio, you go to the Classifications Office for films and videos, you go to, there's NetSafe when it's individual bullying, there's the police when it's criminal activity. It feels like everything gets so complex as a member of the public when you want to push something. So that's just something to think about as we go into the next questions, because I'd be interested in hearing your thoughts about that. But I'm going to go to Kyle next in terms of barriers to legislation.
Yeah, I mean, I think I can't believe we're still in this operating context, but I think that one of the biggest barriers is, and this still comes up when talking with legislators, is a misunderstanding that at the core, these tech companies are private businesses trying to maximize profit, right? And so anything that the government does that they could view as impeding in that aim, they're likely going to oppose. And their business models are built on data extraction, which they take without compensation, right? So privacy inherently is contradictory to their aims. And privacy is one of these fundamental things we're trying to achieve through regulation. And that goes as well with the types of content that are potentially harmful at scale. So I think one of the biggest barriers we had is, and there's this deferral that we really experienced, a constant deferral to them on whether things were technically possible, right? So we would go to a hearing, give evidence or something, and then the follow-up would be, well, we spoke to Meta and they said that wouldn't be technically possible, so we're not going to pursue it. And it was sort of like, well, who's in charge here? And of course, they're going to tell you that. So I think that's a really important thing to keep in mind, is that, there is an opposing party who does not want a thing that maybe you want, and to really not necessarily take everything they say at face value. And then a second piece, is just a lower technical understanding of the services themselves from legislators. And so doing a lot of how things work sessions early on, like, for example, this is how encryption works, right? Or around age verification, right? So I think, and I don't want to go on too long, but I think this touches on a really important point. To ensure whether or not someone is a child means you have to prove affirmatively that every other person is an adult, right? And that's the only way you can know who's a kid and who's not. So any legislation that says children are banned thus requires every adult to give their private information to some entity. And so if that's something that's being pursued, and whether it's really important for legislators to fully understand what that means, what the process is, and if they're inevitably going to go down that route, to ensure that the process itself is third-party privacy preserving and not a further data grab for the biggest companies. But those are the technical things that you cannot assume legislators understand, even though 14-year-olds understand it. And so that's a huge barrier for legislative change, is legislators understanding what they're legislating.
All right, point. I think, Katy, you haven't gone yet.
I haven't, but I'm not sure what else I can add there, because I think Kyle's put that very eloquently. And I would only be repeating also points made by David as well. So shall we move to the next
Yeah,
question?
yeah, I'm happy to do that. So my next question is, have you seen anything that's actually worked well in terms of regulation, something that has reduced online harm or have been effective anywhere in the world, anywhere from your experience? Because we're looking at, what are models that we might want to at least try to learn from and follow in a positive way. So I'll start with you, David.
I was hoping I could go last on this one. I should say that I and my colleagues, we're watching really closely to see how things work. A lot of this is still very early, so watching closely how for example, how the transparency and access requirements of the DSA, if these end up helping people who use online services, if it ends up helping them at all. If the requirements that very large operating platforms, very large online platforms, that they disclose a ton of information, and that information hopefully be made easily accessible to the public, that researchers have certain access. These are things I think all have the potential to be of great benefit to internet users. But I think it's still too early to tell if we're going to see those benefits, and some that might be the way of the law. Sometimes I think it's the companies purposefully gaming these obligations so far, and trying to avoid having to comply with them as much as possible. I think we're watching the EU's GDPR, their data privacy regulation. There's large parts of it I disagree with it, but also large parts of the data privacy regime that I think are really important, that seem to have been beneficial, not just in the EU, but in other parts of the world as well, from companies trying to comply. But it certainly has not been a complete solution, but we are looking at research to see if it's taken a bite out of some of the privacy harms globally. I think as Kyle mentioned, because of the problems with age restrictions online and the fact that so many of these laws are focused on age restrictions, is that the implementation obstacles to those that have gone into effect have just been really huge, running up against the sort of the current state of development of age assurance and age estimation technologies, the failure to account for the data privacy harms in those laws. Anyway, we've talked about it already, but I just say it's a little too hard. It's just. So I don't have one model I can point to, but there's lots of things we're looking at to see how they're effective. I'm very skeptical about Australia's law that goes into effect in the new year, but it will certainly be interesting to see if it has an effect. And actually, one of the things I'm following really closely is some of the competition-focused efforts, regulatory efforts at the large companies, to see if those will have an effect that will benefit users as well, in terms of are these companies part of the problem that we have a few companies that are so influential and powerful that their editorial decisions have outsized global significance. where virality on a single platform becomes such a huge thing because has so many individual users, as opposed to where that wouldn't have the same effect if it happened if these were smaller and decentralized decision making nodes.
Yeah, great, thank you. Katy, I'll go to you next.
So I think this is the hardest question. And with the caveat that David's put in there about it being early days. So I was thinking about what could work well. And I think thinking about the Digital Services Act is some of the transparency requirements are positive. So unlike as Kyle pointed out, under the UK's Online Safety Act, we're not going to see the transparency reports. They're going to be with the regulator, but under the EU's DSA, the platforms, or the very large platforms, have been publishing their risk assessments. There was, my understanding is, a lack of specific guidance under the Act on what format those assessments should take. So it's very much an iterative process. But that is an example of, reports that we can see. And I suppose it is already clear, though, that improvements are needed. So with those risk assessments, like the use of kind of data and metrics to show how effective the mitigation measures are, and also how to ensure more meaningful stakeholder engagement across the tech companies, the governments, the regulators, but also civil society. So even though we've got those transparency reports, civil society organizations following this more closely have still aired concerns that they're still not sure what risks are most prevalent or what the data is that's gone into determining those risk levels. So I think it has the potential, that transparency reporting under the DSA, to work well, but it is that iterative process.
Great, thank you. Muderhwa, do you see any positive examples of legislation?
Yes, actually, there is some positive so across the continent. So we take, for example, in South Africa, we have this POPI Act, which regulates online privacy. So it's being enforced, and we've seen it being applied, and there's a follow-up when it's come to companies and their fines. So everything is in place to make sure they comply to this. So it's not only us, but when you look at across the continent, so many countries, they are taking the same step. So the implementation is at different level, but there's something that is going on. But also we've seen some governments being able not to engage with tech company to make them accountable to whatever or what is going on. We've seen Kenya. We've seen things happening in Kenya, things happening Ethiopia. So there's some progress, and there's hope. They'll be able to engage and to make account of some of this tech company, of what's going on online.
Awesome, thank you. And Kyle?
Yeah, I have three specific to mention, but I think it comes with the same caveat of a lot of it's new, so it's going to be, will these work? We're in the middle of finding out. So I think one is the Network Enforcement Act in Germany, which is around terrorist content. I think they're in the middle of doing an assessment, a 5-year assessment on broader impact. But I will say what it did do is force companies to increase their content moderation abilities in German. as a result. So that was a positive in terms of a push-pull that got content moderation up to speed. I think the other two that are interesting to keep an eye on, in Taiwan, the Ministry of Digital Affairs, so they have an entire ministry specifically to the digital world. They have this fact-checking alliance that does instant fact check within a few hours, and then a longer fact check within, I believe it's 24 hours, but it's well funded and well resourced. And I think the key there is that there's this underlying shared experience where Taiwan is under constant threat from disinformation from mainland China. And so as a result, there's also a shared societal understanding for the need to have trustworthy information. And those fact-checking alliances are from independent organizations. So I think that's one definitely to watch. And it's the Taiwan Fact Check Center is the hub of those fact-checking initiatives, where we've seen in I don't believe it was ever fully required in the US, but in the UK, the fact-checking has all but stopped. Because the companies have stopped even doing voluntary fact checking. And then the last is in Japan. So they have a information health initiative, it's called, and that's around disinformation and illegal violence and extremist material. And what I think is really cool in this piece of legislation is that every 3 years there's a civil rights audit of the bill that's independently done outside of government to determine whether the legislation is over impacting on people's civil liberties that are guaranteed in the Japanese Constitution. So that happening every 3 years, independent of government, is a really interesting model to consider, because the root of all of this is, well, who decides what's true, right? Like ultimately, when we're getting into disinformation, violent extremists, we're saying who's deciding if it's violent or extremist, and that is another perhaps piece of the puzzle early on to be thinking through as you approach legislation. But yeah, those are 3 examples just of different aspects that work.
Awesome, thank you. I'm just looking at the time, so I think I might just go to a couple of the questions in the Q&A. The first one, which refers back to my point that a lot of our legislation is outdated. What are the panel's views on the Act structure of having an independent body classifying content to act as a litmus test or guide to platforms, as opposed to the platforms or the free economic market determining what content harms are legal? So this is referring to our classifications office, who are statutorily independent, and that the chief censor here can go to jail if they're found to be bound to political interference in any way. So they've got some really strong protections around that. I know that Australia has an e-safety commissioner. I'm not sure that they have that level of protection. I don't know enough about Ofcom, but to say how statutorily protected they are. But yeah, how do we think of that as a model for going ahead with this sort of area? Katy, I'll go to you first.
Thank you. So I would be in support, in theory, of the structure of having an independent body, depending on what protections you have in place for how independent that body can truly be. Something I will say, though, is it would be important that that's not seen as the fix, as the safeguard. If you take Ofcom as the independent regulator in the UK, it's bound by the Online Safety Act. So you have to get the regulation right in the first place. And I suppose my, given the experiences of the Online Safety Act and other types of regulations, such as in Germany, or the EU's terrorist content online regulation, is whether you want a structure that is about classifying content and going after specific categories of content, as opposed to the points Kyle made far more eloquently in terms of thinking about risks, mitigation, transparency, and redress. So to move away from this take down, leave it up. And I suppose if you're using the model of the New Zealand's Classification Office, kind of thinking about how would that operate at scale? Because at the moment, my understanding is they will classify like a very specific piece of content, like a terrorist manifesto. But it doesn't, other bits of this regulation, they're almost trying to predict what suddenly might amount to harmful to children or hate speech. I'm not sure how you would work that out so it would be operationalized at scale. So yes, I'm in favor of an independent body, but perhaps not on a let's focus on categorizing content model.
Yep.
And
Thank
actually,
you.
Kyle's mention of the Japanese setup sounded positive.
Yeah, I'll go to you now, Kyle, just to keep the
Yeah, I
thought.
mean, I think I agree with Katie's points there. I think in the UK there is a model by which an independent body can be created through what's called a royal commission. And so press regulation and the independent press regulator that did not end up becoming compulsory was set up through that model. And so it would be context specific into what in your context would people accept as independent. In the UK, that is near universally accepted as being truly independent of government, industry, etc. The money comes in separately. It sits in a separate space, so they don't have an inherent interest to benefit industry or government through that model. And that, of course, that it's impossible for anything to be truly fully independent, but we're working within the frameworks that exist in our societies. And I think, just to echo Katie's point as well, the question is always about mitigation, is working at scale. And I think it's an interesting point to be made around tech companies, because effectively where we are is everyone acknowledges that their products aren't safe, right? Like that's what's understood. That's why and yet they're allowed to continue operating. So if an individual, if every billionth coffee Starbucks sold killed somebody, Starbucks wouldn't be selling coffee anymore, right? But in the tech space, we sort of view it as different, as serving a different role in society, which is, I agree, but then as such, you have different requirements within society, right? If you're a necessary service that we now depend on, then effectively, as a public utility, you have other requirements in society beyond simply making money. But that's a broader reclassification and a bigger conversation.
Oh yeah, down capitalism conversation. Nah, kidding. David, I'll go to you.
Yeah, so I guess I'm all for lots of people telling platforms when they think stuff on the platforms is bad or when their practices are bad, and even exerting pressure, whether it's political or social pressure, in order to get platforms to do the right thing in the face of this enormous economic pressure, right, that they are facing. And I think we all here agree that we don't have a ton of trust in these platforms to make the decisions that are good for humanity, right? They're all going to make the decisions that are good. Or I should say the big ones are going to make decisions that are good for their bottom line. So I'm all for having, whether it's private entities, or even private entities, independent commissions that help inform these processes. I'm not myself. I get very concerned about having non-judicial bodies making determinations about what speech is legal and is not legal, especially if a consequence of that is that someone might not be able to access the information, or even have more difficulty accessing that information than they would otherwise, because I get very concerned about those systems having majoritarian effects on speech. And I come at this up as a perspective from as a human rights lawyer, where my concern for freedom of expression is that when we do tend to have top-down speech regulation, it's always at the expense of minority voices, what minority speakers want to say, what type of information they want to access. When we're talking about young people, harms to young people, it's never about what are we doing to protect the most vulnerable young people who either are not as supportive family environments, who want to explore sexuality that might not be popular within their community, or religion that might not be popular within their community. And so I do get very concerned about any type of external body that is going to essentially make a majoritarian judgment about whether something is harmful or whether information is valuable. Obviously, there are completely different things if we're just trying to make a factual determination, this is true or this is false, and that answer is easily obtainable. That's a completely different situation, and experts can be really well placed to do that. But generally, in terms of when we talk about harms, we talk about content harms. It's so easy to step into this role where we are not, where we are once again going to find the people who are most vulnerable having another law being used against them to silence them, and people who are in the majority of users, majority of viewpoints, majoritarian populations feeling no effect from these things at all.
Great, thank you. Muderhwa, I just want to check if you wanted to add anything there about independent regulators.
No, I'm in line with what has been said. Yeah.
Okay, that's great. Thank you. And I'll just do one more audience question that refers to the Rwandan genocide, and that online systems weren't available, but the use of newspapers and radio, that were demonizing a population. And, is there any regulation that can protect whole groups of people from opposing groups, but especially their own government, making slurs that could lead to genocidal tendencies? And I think, this is a common concern globally, not just Rwanda. We've seen the Rohingya, we've seen Tigray, we've seen other places where demonization of a community has led to mass violence against them, and that often the state is complicit within that. So I'm going to go to you first, Muderhwa, to get your perspective on this, and how might we use regulation, if at all, to deal with such a problem?
Okay, thank you. So that one this question is a bit personal because I was in that region. So I was growing up when it happened. So we could, from the border, I was living cross border in DRC, so we could hear that radio, the way it was broadcasting. So, and that's for me, I'll bring back to what I mentioned early on when it comes to language. If I know, if I'm not wrong, when the message was being passed, it was being passed in the local language. And we know up to now, most of this platform, when you do something in those, if I can call it a big language, like English, Arabic, those known language, easily they can catch it and bring it down. But when you speak to some other language, it's easily go through. So when I look at it, and like you mentioned, it's still happening. And most of what's happening for me, it's yes, the regulator as well, but unfortunately, sometimes we may see governments being involved in this. So when the government is being involved, it means we don't expect too much from them. Maybe the hope will lie on the owners of the platform to make sure, like the blog, whatever, it can be considered as harmful. So for me, I look at it as I think the platform owners should be very should consider like some of to grow the language, because some of the language that are not so popular, to make sure, because when the government fails, actually it's the life of the people. It's people that are in danger, people that are suffering. They can at least bring down, those kind of content. And we've seen what happened as well, I think it was in Ethiopia, something, happened like that. So also I would see, maybe I'll look at when it's come to regional, maybe we should have something on the regional levels regarding when it comes to regulating this online hate speech online, because if something can't be done by the government, but if at the regional level it can be done, it can also help. I remember during that time, I'm just taking the example of that one. Yeah, people dying. We could hear on the radio on the opposite, like I was living in DRC opposite Rwanda, but nothing was being done like concrete in the regional level, and people are dying. So for me, in this case, it will be like, what mechanism we can put in place, like in a region, like if one of these government doing something like this, how the regional level they can maybe we can have in place some rules. They can be in touch with those same tech company to make sure, like, to prevent such kind of things. Yeah, I'll stop there.
Well, no, thank you for sharing that. And I can understand that it was going to be a difficult question for you. So I really appreciate you sharing. Kyle, I'm going to go to you next.
Yeah, I think this is a really interesting question. So I actually did field research in Bangladesh in Cox's Bazar, interviewing Rohingya refugees who had fled Myanmar and the genocide against the Rohingya there. And I spent 2 weeks in Rwanda as part of the comparison of information flows and how it affects violence, how it impacts violence at scale. And I think the underlying piece is around control and power over how information moves. So, radio actually still touches 90+% of people on Earth. It's a really effective communication tool, and it was the primary tool used in Rwanda. But the difference that we see with the information flows is that while radio is public and you can hear it, even if it's not directed at you, algorithms that drive content on social media are siloed. Every individual feed is different, and information is targeted to maximize engagement of each user. So it may be that something's happening and the impacted population isn't even hearing about it, which is the case of the Rohingya, who were barred from owning smartphones in Myanmar. So they weren't even aware of the genocide that had started and was being facilitated on social media to perpetuate harm against them. And I think this speaks to, and the core that it came back to was around trust. Who do people trust? Their government, or private companies. And when you have a low trust government, people tend to lean on private corporations and private products as a tool of protest. I knew it would come to me. Protest to that state. And this is what makes this regulatory space of social media so complicated, because in some places it is a tool of freedom, and in other places it is a tool of oppression. And I think it's why we're looking at these global corporations that, Facebook has near 3.5 billion active monthly users, and yet they're operating in such different contexts all around the world. So is there one universal approach, or does everything need to be considered within a context and a region or a specifics based on history, trust, and all these other factors? But yeah, I mean, the core piece is who controls the means of communication, I think.
Thank you. Katy, if I could go to you on that question.
Thanks, Ange. Just briefly, I suppose, going back to product design. So from what Muderhwa was saying, if a company is thinking about risks on its platform, it is a risk if it is lacking cultural, linguistic expertise. And we know the impact of this, and we know that the big companies who can afford to improve expertise in these areas can. So when you're lacking that expertise, and there's clearly a risk, we've got lots of evidence that it is they need to do something about it, and that includes the impact of the algorithms in what we can see and what we can understand, and how that's suppressing minority voices, or the impact of that in different countries, depending on
Thank
who's in
you.
control of the information.
Yeah. David.
Yeah. Kyle said a lot of what I was trying to figure out how to say, and I'm glad that he was able to say it better than I think it would have come out of me. So I appreciate. So let me just add on to this, is that when government speaking is the problem, it's hard to find a regulatory solution for that, because ultimately the government is the one who's going to enforce the regulation or decide that the regulation doesn't mean anything. And it does put us in this very difficult place of either having to then empower the companies to be able to stand up to the government. Because even if the companies realize, wow, the government is doing really awful things with our platforms, they still need to have the ability to then respond to that. They need to have some type of legal protection against those governments, to be able to stand up to them, or to say, we're not going to publish your speech, or if they choose to, we're going to de-amplify your speech. So even if you assume like the well-intentioned company that really wants to do the right thing, which I think is largely a fiction, but even if you assume that, you're going to need to then empower them by regulation to do that. That type of empowerment might be completely inconsistent with the type of regulatory restraints you might otherwise want to put, where you're allowing government to actually restrict the tools that they use. So I think it's a very difficult. It's hard to look for a regulatory solution to government being the source of the problem, unless you have a government that's willing to submit to its own speech being curtailed, which I think would be an awesome thing if it were to happen. But again, when you have a government in power that is the one who has the ability to enforce laws, and to even choose the laws to be non-operational, it's really hard to look to regulatory solutions to the government being bad actor, at least on a local level. We really think we end up defaulting to more of our international legal bodies to address a particularly bad governmental actor. And again, these are I'm saying all that, understand that's a tremendously unsatisfying answer.
Thank you. I'm seeing that we're starting to get close to time now, but so I'll just ask the last question that we have planned, and then we'll wrap it up, which is and I feel like we've covered a lot of these, so if you don't have anything new to say, then that is perfectly fine. But any unintended consequences or problems that you've seen that come out of legislation. So I'll go to you, Carl, first.
I think most of the regulatory environments in which I've been working, we're not yet seeing fruition of the plans. So I don't think anything. I would say that things like watering down of transparency requirements and mitigation and risk assessments is an intended consequence from the tech company's perspective. And so holding on to, so I guess I would just say, as you're approaching this in your context, is holding on to the stuff that's free to the government. So transparency requirements and setting standards for redress is really, really important. So you don't have the unintended consequence of not getting any transparency, at least from the legislation to study. But I think, and the last piece, which I think David will appreciate, is there's always the unintended consequence of a chilling effect on free speech and free expression. And so mitigating that, and I think, but David made the really important point of when it's the state that's actually doing that, how do you redress it? So these are tricky questions. This is not easy. 8 years of my life, no, nearly 10 years of my life now focused on this. And every now and then I'm still like, yeah, actually, no idea. doing our best.
Thank you. Muderhwa, I'll go to you. Anything that you've seen?
I think I
Yes.
said my all I have to say, yeah. So
Okay. Yeah. No, that's cool. Thank you, Katie.
Yeah, so I maybe we'll mention something we haven't spoken about because yeah, obviously the chilling effect on free speech, I think we've all agreed on, and particularly the harm being suppression of minority voices. Something to keep in mind as well when designing legislation is most of which is designed thinking about big tech, Meta, TikTok. So we need to think about that in terms of free speech, there's consequences in terms of capturing all platforms in that kind of category. And that is still playing out a bit in the UK. So we've had Wikimedia try to challenge that they're being categorized alongside Meta when they're quite a different platform. But this is another thing on Ofcom, the regulators' list to sort out over the next few years. But that's something to watch out for, how you categorize the services and platforms.
Great. Thank you. Last word
maybe
to
I may,
you, Gabe.
maybe I may add this.
Oh,
Sorry.
okay.
Yeah, maybe I may
No,
add
jump in.
something. What we noticed. So I'll just add to what Katy said. So we've seen we always talk about big platform, talk about the government, but we don't talk much about us. When I take like us as parent educators, what is our role, and we tend to blame most of the time the owner of the platform. So for me, I think there's a lot of work that is being has to be done on the side of parents, of educators. Why I'm saying it, there's something happened. I had my little one, she was playing with tablet, and then she came to me, she said like, someone is SMSing me, is writing it to me on the tablet. She doesn't know how to read, but she saw someone writing to her. So I was like, okay, who am I to blame? The tech company or me as a parent who let my kid touch, work on the tablet which is connected. So yeah, that's that.
Okay, over to you, David.
Yeah, with the caveat that although these might be unintended, they certainly are not unknown because I think regulators get warned about these things all the time. And we already talked about the idea when you have the sort of institutionalizing sort of age verification and age assurance estimation systems that the sort of the speech and privacy harms that's going to have on adult users. But I want to lift up the point that Katie mentioned, which is a lot of times our problems originate in the fact of having these communications platforms dominated by a few highly centralized, very, very large companies that we have no trust in, that make decisions for their own financial interest and seem to have little concern for their users' interest or rights. And yet, many times this regulation has the effect of giving those companies huge advantages over those who might be competitors to them, whether they are smaller commercial services or especially non-commercial services who tend to be highly disadvantaged in terms of the resources they have available with them to comply with laws. The EU's law tried to address this in terms of trying to have sort of tiered compliance measures in terms of size. But these are but we're still seeing a lot of small services, public interest oriented services, decentralized. The other thing, these laws do really bad job with decentralized services. So services that don't rely on a single decision maker, but allow for a wide variety of practices and sort of small operational nodes. All these things tend to be put in a really, really bad and difficult and almost impossible compliance position by these laws. And so I in some ways we end up, especially when you consider the political power of the large platforms to control or at least to highly influence the debate, we end up passing laws that tend to give them great advantages in the market instead of actually making them make better products and treat their users better.
Great. All right. I'm going to wrap us up now. First of all, to our panelists, I know early mornings, late nights for some of you. I really want to appreciate your time, your expertise. I've found the session incredibly useful in terms of the different perspectives that you brought to these really difficult issues. And so thank you for staying the course. Thank you for our audience. And we have recorded the webinar, so we will make it available, and we'll be promoting it through our social media and hopefully with our partners promoting it as well. I want to thank our tech support person in the background who has made sure that everything has flowed through. And the final thing that I will do, which is again a tradition for Aotearoa New Zealand, is finish with a closing karakia. Unuhia, unuhia, unuhia ki te uru tapunui, kia wātia, kia mama, te nākau, te tinana, te wairua i te ara takata. Ko ia rā e rongo, whakairia ake ki runga, kia tina, tina. Hui e, tai ki e. All right, everyone.